exempted that from disclosure under 234C of the government code. However, she subsequently directed Mr. Garza to go to the record room
Right.
and obtain it in that fashion so that his right can be violated.
So then what I have a feeling we're arguing about here is the amount of time, and perhaps Member Sims has something to ask or add.
Well, I guess they wanted to add it. It just seems like there is some confusion about who the request was sent to, I think, and then the timeliness of the response. But when it comes to the response, part of the requirements in the Sunshine is that if we don't have this information, we tell you where you can get this information from. So essentially they're saying, we have it, but we can't release it because of this directly to you, but we can tell you exactly where you can go to get that record, which is part of what Sunshine was there for. I mean, they were very disclosing and very forthcoming in that. Now, the other issues regarding filming and, I don't know what real powers we have to, do our own internal investigation of were they telling the truth or were they not telling the truth. I mean, that happens in every single case of a public records request. We can only just hope that they have been completely forthcoming in all the records that they have. From my perspective, I don't see where they haven't been forthcoming, except in the timeliness matter.
Yeah, that kind of stuck with me too. You have something very quick, Member Pilgrim?
So,
Quickly?
can you explain very briefly what gives the records management section, or whatever you called it, the CIS, or whatever they're called, the ability to provide records to the public that you're not able to provide under the Sunshine Ordinance?
It's policy that I understand that the Records Division takes care of the deliverance of police reports.
And where is that policy? Is that another policy that you don't have?
The policy, it was even on our website, how to obtain a police report. But I want to also address regarding the time issue that this gentleman was, I'm sorry, Mr. David Sims, regarding the time incident. This first IDR that was sent was on the 21st, was Saturday. We
Okay.
received it on that Monday. Ms. Humphrey sent a reply back to Mr. Garza on that same day, the 23rd, invoking an extension, and also responding back to Mr. Garza regarding the disclosure exempt from disclosure to 6254C.
So, if I could just follow up with Mr. Garza, if I've not talked to him.
Do you have something for Lieutenant, or?
What I've heard today, maybe from Purple, it does seem that, essentially, I think someone who's been essentially a quote unquote either accused of a crime or detained. Eventually they're going to have to turn those records over to that individual regarding, I guess, a mental health issue, because otherwise they can't go through the necessary due process without giving that to him. So I think that might have been the original reasoning why that process was created, to maintain the differences in their structure, in their own internal structure. I don't know, I wasn't there when it happened, not that old.
And again, I think what we were asking earlier is if those policies exist in writing, I think we would like to see them, because there's some ambiguity that could be cleared up with understanding those written policies, whether it's policy or a DGO or whatever it is. Can I just go to Mr. Garza for a second? So between both of these complaints, what are there any records that you have not received that you requested at this time?
I honestly don't know, because I asked for, all other interagencies, if they communicate with other agencies. I don't know. I don't know what to believe, because as I've said before, this was a red herring. This was not even a valid 5115. For them to bring up medical records, which it isn't, is a false lead. In addition,
Okay, did you ultimately get the incident report?
I did, but I don't know if that covers all the other interagency, stuff that was requested, sent, and everything else.
But you did get the incident report with the attached
whatever detention report?
I'm not sure whether it included the detention report. I'd have to go back and look. You know, I do know that I did go to file a follow-up report on it because it was a false incident report. Because like I said, I was released within 2 hours. Oh, and by the way, let's not forget that what Ms. Conifrey gave me, the information that you gave me, because you guys are just trying to overlook all this, was incorrect. It did not happen on the 19th. There was never any follow-up with that. There was never an admission. I was just constantly played. Oh, and you're correct. Even though there was 10 days for them to respond, I jumped through the hoop, and it probably took another 10 or 14 days after that, which is well over the IDR's 24-hour thing. Set to fail. Now, you keep asking about policies. When will you ask about the policies about the video cameras? Because they've said there's none.
Okay, so I think you answered my question, that you got all the documents that existed.
Well, I believe I said no. That I wasn't sure.
The information we have.
All right. Anything else? So,
Just for discussion, it seems like, yes, there was an extension filed, but I'm not questioning whether that was appropriate. If the answer was, well, we're going to redirect it to our regular policy, we're going to go to this department, get this information, that should be given right away. Why was an extension required, and then taking an additional 10 days to convey that information? That started to trouble me a little bit. If it was as simple as, well, this is how you should be able to get the information over here, that should have been part of the initial conversation that Ms. Conifrey had on September 23rd. What do you guys think about that? So I think it was, you know, it could have been done better. It could be communicated more clearly on the first day, and we probably wouldn't be here. That's just not my thought at this point.
okay, what happens next? We're done deliberating among the task force members. What happens next is the respondent, Lieutenant Moon or somebody else. You get 3 minutes to give us any rebuttals or conclusions or anything, and then
Madam Chair, since this is a dual item, I would suggest 6 minutes per rebuttal.
I forgot about that. You may have 6 minutes to discuss this, and after that, the complainant will also be given 6 minutes. Up to 6 minutes.
I just want to restate that this was not a simple routine request that could be easily answered, as we saw here today in conference of talking about how we would try to gather this information or provide this information. It's not a simple, readily accessible routine request that we can easily answer. This information that we obtained, provided by Mr. Garza, actually, that he requested this information. It was thoroughly thought out, and we need to ensure that there's privacy issues need to be dealt with and dealt with properly. We consider these requests quite seriously, but at the same time, we must understand that there are privacy rights that we must consider. So therefore, regarding the time constraints, I believe that it was proper within that time stance, because not only we must provide this information to Mr. Garza, but we must provide accurate information. There's no use providing information that's accurate, not accurate. We provide accurate information to them, then that's even more beneficial to them, obviously, and we owe that to the public for that. Thank you.
Thank you.
Mr. Garza, you have up to 6 minutes.
Well, I love the mantra. We must provide them with accurate information. Did I receive that? As a matter of fact, the information I received from Ms. Conifrey was that this incident happened on the 19th, not the 18th. How accurate is that? After all their due diligence, after all their professionalism, after them knowing what the policies are when it comes to, delaying me in getting what I need. Was it voluminous? I think it was maybe 5-6 pages that I received on this incident report. Was it voluminous? They're worried about my privacy. Why didn't they send me to that place like you said initially, and why couldn't I have gotten it immediately then? Privacy? It's my privacy that we're talking about here. It's also an invasion of my rights when, they didn't even have any policies for their video cameras. Oh, and let's not forget the video camera that was behind the area that belonged to an individual while on duty that recorded me that they stated was erased. How dare they? That was performed, and that video shouldn't have been erased. Just because they've done wrong things doesn't mean that they should get away with it. This professionalism that they keep wanting to tell you about and everything else and how professional they are. Well, why did Ms. Conifrey, as the most knowledgeable person, why is she not here? It's wonderful that Mr. Woon is channeling for Ms. Conifrey as opposed to what she might have thought, what she might not have thought. But, to have already received incorrect information from her and for me to write her back and call her on it and say, well, now I'm demanding an apology and admission of this so that I can have faith in what you're sending me and trust you. Because it was incorrect, and to receive no follow-up and to continue to be played by their, shall we say, less than correct system. My God, they have a policy for how they release incident reports, but they don't have policies for their video cameras at the police stations? Huh? This is all a game. As a matter of fact, like I told you, every other police station I went to said that they did record. So where are those recordings, or where are the policies? You should be asking about those policies. That is very, very important. Because do these cameras record or do they not? Have I been lied to? Now, like I said, in a post-9/11 terror world, Homeland Security, I'm pretty sure that if they got any federal funding, that these video recorders must record, as I was told by the other police stations. But when Ms. Conifrey can send you something that's incorrect, not account for it, and somebody else can send you something and she can just whitewash it off and say, well, this is what I was sent, and not check on it, and then there's no policies, this stinks to high heaven. Beyond high heaven. Now, the other thing, like I've said many, many times, they keep bringing up that these are not my medical records. This was an incident report. My medical records, I sunshine the Department of Public Health, and no, I have not received them for this false 5150. I didn't receive my medical records when I went down and asked for the incident report number that he's claiming it was in my interest to protect my privacy. I didn't receive my medical records down there either. Don't be fooled. Don't be misled. Don't play into their game of look over here but not over here. Look at the complainant who is telling you that he filed a proper IDR. He got incorrect information. He followed up on it. He jumped through their hoops, even though he didn't believe it was his responsibility. He continued to follow up and ask the appropriate questions and go in. Still couldn't get any help from this person when I went in. Those videos are on YouTube for me trying to follow up. And now this person's not here. Hoodwinked. Policies. Protocol. Excuse me, I'm truly not understanding any of this. You must remember, I went down to Northern Station to continue to follow up on the denial of my health care and reports that I was following up with. I was in no way, shape, or form confrontational, 5150 material. As a matter of fact, the videos would show that. My video that's on YouTube, you don't even hear anything in the background of my video for them to claim these things. But when they can fool everybody and say, hey, this disabled person, doesn't deserve the videos because we don't have any policies for that. But we sure do have policies for how he can go down and get the incident report that isn't even medical records, but yet tell him that we can't allow him to get this because in the interest of his own privacy for medical records. Huh? Any port in the storm. Any port in the storm, other than doing what's required, other than, trying to be helpful and resolve it, other than finding an alternative, misrepresentation, misinformation, no accountability. I will repeat it for a third time. When I requested this information, she sent me that this happened on the 19th when it happened on the 18th. Truly reflective of the police department's due diligence.
Thank you.
Madam Chair?
Member Mead?
Yeah, I hate to drag these things out, particularly in the interests of timeliness of provision of records to a requester. However, I think we owe our thanks to Lieutenant Woon for coming here today. He's answered questions in as complete and forthright a manner as he could. I don't think it's complete enough. There were questions he could not answer that he told us that perhaps Ms. Comerfrey could answer. And particularly, there was a question that Member Pilpel asked about why records could not have been provided in redacted fashion. I think that's a very vital question here. And I would like to, I'm going to move that this item be continued till the next task force meeting, and that Ms. Comerfrey be asked here to answer the questions that Lieutenant Bloom was not able to answer.
Mr. Clerk, Ms. Comerfrey is no longer with the department.
Does that change things?
Well, could I ask Lieutenant Bloom back to the microphone, please? Is there any way that you could obtain the information that you were not able to provide today, either through contacting Ms. Comerfrey and getting answers from her, or through contacting perhaps somebody else in her office?
Regarding specifically which information, sir?
Well, there was there was a question of whether Mr. Garza was informed about the privacy issues on his medical information, and also the question of why the information, rather than being withheld, could not be provided to Mr. Garza in redacted form. Please.
This is Sergeant Pedrosa.
I was, some of the questions you have regarding the timeliness and all of this, I can't speak to, but I just want to try and clarify a little bit about the release of the police reports. I'm the supervisor at Police Legal, and I was Ms. Comerfrey's supervisor at the time, and I'm still the supervisor at Police Legal. And like I said, I don't have a lot of specifics about this, but I know it for Mr. Garza's case, and for anybody here on the panel, for anybody in the public's case, it's illegal. For the police department, not only we've been talking about protecting Mr. Garza, also protecting the police department, it's illegal under the Welfare Institution Code to release a 5150 report to a person, even redacted. The records I have a unit of 14 people. Our records management is, I believe, 50 to 60 trained people on how to and when to release records. I believe that, and you can ask Mr. Garza this, but in order to obtain any record, because of HIPAA regulations and because of the Welfare Institution Code, if you go down to the records room to receive your record, not only, I'm not sure if you have to sign a waiver or not, but I know your ID, I know that ID is scanned and kept on record, so nobody, Joe Blow, can go down and say, hey, this is me with a fake ID and get the record. Now, you would have to ask Mr. Garza. I never had to get a medical record for myself from our records division. You would have to ask Mr. Garza if a waiver was signed and if an ID was presented, but my division and the police department in general, whether it be the chief's office, or Police Legal, or Lieutenant Legal, or myself, or Maureen Comerfrey, can't provide anything lawfully under Welfare Institution, even redacted, to anybody requesting a
What
police
code is
report
that?
with any medical information inside. I mean, 5150 Welfare Institution report does have medical information, no matter how minor it is.
What welfare code is that?
Sergeant
Member
Pedrosa.
Hyden?
Sure.
I'm sorry, could you pronounce the name again?
Yeah, Pedroza, Pedroza.
Sergeant Pedrosa. So it sounds to me that there is a pretty standard policy in place for these kind of requests, and you just cited it,
Well, the Welfare Institution Code in general states that. I mean, I'm not being, yeah.
My question here is, why did Ms. Comerfrey not present that information right at the beginning?
I almost kind of presented, I believe, from what Lieutenant Woon said, he's the one that's been studying the documents, that, Mr. Garza was directed to the records room, but even if it wasn't done right away, it's, I mean, not exactly written, but.
So, just to refresh your memory.
Sure.
September 23rd was the invocation
I don't know.
extension,
Probably.
and then October 1st, she presented that information to him.
Okay.
But it sounds to me, the more and more I hear, this is a pretty standard protocol. So
Yeah.
in the efforts to educate the public
Sure.
efficiently,
Mm.
why would Ms. Conifrey or any of your reports not present that information right away?
I don't know
was
when
trying
it-
to see, well,
yeah.
is there a standard?
I don't know when it was presented, but I'm almost, and I'm not trying to be facetious, I can't go out and rob somebody because it's state law. I don't have to be told that. So, and like I said, I'm not trying to be
Let me rephrase the question. As Ms. Conifrey's supervisor, what guidance would you have given her for these kind of requests, or anyone, or her successor, who's?
Oh, well, she wouldn't need supervision for that. She would know, she would cite that reason. When it was cited, I don't know, but that's the research that the lieutenant's done. She wouldn't need guidance on how to do that because
Pretty standard.
she knows, yeah, very standard.
And who's her successor?
Her successor right now, we have another legal assistant taking on her duties, but that only started 2 days ago, so it doesn't matter. But even that person knows that. I mean, it's kind of basic knowledge under the welfare institute.
Thank you for being here in that
Sure.
respect.
Member Neal, do you have anything else?
No. Was there a second to my motion?
Oh, you had a motion? Oh,
Yes, the motion was to continue, but if there's no second, it dies.
Okay. We'll consider that tied. What?
Not really. Go on. Well, I'm considering another motion.
Okay, here. Then go ahead,
Okay, so,
Member
Lieutenant
Cook.
Woon, I was looking in,
go on back.
the Welfare and Institutions Code and maybe, Sergeant Pedroza. I'm trying to find the language that you referred to about, incident reports being confidential. Do you know where I can find that in the Welfare and Institutions Code?
I wasn't referring to incident reports, I was referring to any medical conditions protected under HIPAA. Yeah, nothing for the San Francisco Police Department.
Okay, but I think you said that was
Yeah, under
state law?
under the Welfare and Institution Code, you're the only one who can obtain your own medical records.
And you tell me where to find that?
No, I have no idea, the code is way too large for me, sorry.
I'm in 5150 to 5154, and I'm not finding it. So, I guess what I'm stuck with right now is whether or not there was a violation for failure to provide a redacted copy of the police report, not the incident, not the detention report that we were just referring to, but the police report itself. It seems to me that a redacted, perhaps heavily redacted, version of the police report could have been provided under the Sunshine Ordinance. But, I don't know. Is there any feeling among the members that that has been trashed? Anybody? No?
Anybody?
Alright.
Okay.
Well, it depends on whether the request was for the incident report or the police report. If there was no request for the police report, then we're done. If there was and the incident report, according to the officers, is not releasable public information.
Right, although the reason for non-disclosure that was cited, the 6254C reason, is not this Welfare and Institutions Code reason, and that Welfare and Institutions Code section was not referred to in their justification for withholding. So either they needed to provide a heavily redacted version of the police report, or a better reason than 6254C for non-disclosure. And if there is a specific citation, that should have been provided under, 67.26, justification for withholding.
67.26. 67.27, I believe. 67.26 is minimal withholding. 67.27 is
Twenty-seven
justification.
justification, that's correct.
Might I state that the police report and the incident report are the same thing?
I'm not sure if that's true in this case.
Well, regardless, in his original IDR, he does say the police incident report, so I would agree with Mr. Garza. Just trying to make it as inclusive as possible.
Am I hearing any questions?
I'm still getting there.
Madam Chair,
Member Need?
I'd say at the very least, we have possible violation of 67.21 B or C. Immediacy questions aside, you know, that's open to question, but
Would I have a second?
Well, just to add on to that, I mean, I like the fact that they were in touch, they responded, they continued to respond. He did ask for a lot, and when you throw in the video stuff, that's a whole other area. Perhaps that should have been, formulated as a separate IDR, and if they can separate it, then they might be able to respond more quickly. I still think that 6254C information was not delivered as quickly as it should have been. And that's the main problem I have here. I'm gonna take a look and see if there's a motion that addresses that. But at the same time, I don't want to punish the city department that did respond in a timely fashion, invoked an extension, because all that was good. And they did direct them to the correct area to get the information. So it's a tricky one here. I think we need to think about it a few more minutes before.
Do we have a motion on the board yet?
no, I haven't made a motion.
Okay.
I gave you some out loud
Yeah.
thoughts, but I haven't made a motion.
So
Member Philbell?
why don't I try the motion and see?
Why don't you?
Almost like being emotional. To find a violation of 67.26 withholding of records, or, well, problem is, it's either 67.26 or 27. So either the record, either a heavily redacted version of the police report, I think, should have been disclosed, or the justification for the withholding should have had more explanation than 6354C, which it sounds to me like doesn't necessarily apply, but it's probably a welfare and institutions code reason. So I think either way, one way or the other, I think it appears to me that there may have been a violation. I'm having trouble as to which. Member Need?
Does it have to be an either or, couldn't it be both? 67.26 and 27.
Okay. I would need a second to clean this up. Okay, I heard a second.
Do you have all that, Mr. Burke?
The motion is to find violation of 67.26 and 67.27 for the withholding of records.
Second. Wait, we have a second already, right? So, shortly, we will have public comment on that. And look, the public is ready to comment. Do I have any public comment?
Thank you,
We have 3 minutes.
Acting Chair. I am speaking against this motion because it appeared from what I heard that the initial request was for the police incident report. There are other kinds of incident reports, like the ones generated in the department I'm Garza asked for a police report. He asked for an incident report from the police department. And it sounds to me from what Sergeant Lund, I didn't catch his name, he's in my hearing.
Lieutenant Woon?
Him, yes,
Lieutenant Woon,
thank
yes.
you, because of my hearing loss. Sounds to me like Mr. Garza was directed on the spot to an alternative location where he could have picked up the records the same day. He just appears not to have wanted to do that. So, even though Mr. Pilpel is taking a real reach to find some citation in the Sunshine Ordinance to support Mr. Garza, I'm speaking against this motion. I don't think you should find willful failure or anything else against the police department, and I respectfully suggest that this matter should not be continued to some future meeting where you can quibble over this some more. Thank you.
Thank you.
Yes, before I start, I would like to quibble over 3 minutes versus 6 minutes on a double case. And I would like to ask for 6 minutes for public comment, since this is 2 cases being combined.
Let's stick with 3 minutes.
And that's one of the reasons why combining cases is a bad idea, because you get into discussions and arguments that take away from even the minimal time that you're allowing. This is something, as I said, that I have not followed with respect to looking at the record, but there were a number of points that seemed to me that I appreciated coming up, and particularly by members of this body. So the first thing that I found pretty odd is that there was a record deleted, according to one of the officers, and that, I think, is very problematic. Is there such a thing as a private videotaping in a police station? I don't get that. What are the policies about that? And I do think there's a portion of the Sunshine Ordinance that references the destruction of records as opposed to the keeping of records in a proper way. So that I found very problematic. The second thing is, I think you've properly stated that even if every bit of content of a record were to be redacted, that record might still have value to the requester. And I can certainly give examples of that. What are the portions of the form? What are the elements of the form? What questions are asked? Or information has to be provided? Any number of things can be useful, and so it seems to me that, in fact, a redacted form needs to be provided with a full explanation. I was very troubled by the last-minute production, as I think at least one of your members was, by the last-minute introduction of a flat-out assertion that it's flat-out illegal to provide what was requested when that has not been put into the record before. I think you should also ask whether Ms. Comfrey is still working for the city and not whether she's not working for the police department, because if she is working for the city, I think you certainly have every reason to request her. Member Sims says he doesn't know the investigative powers of this body. I think Member Lee and other people who have a longer history do have an understanding, and it would be appropriate for you to ask for specific people to come, for specific laws to be cited, or for yourselves to do specific research. I think also that to be fair to the complainant, you should discuss each and every violation section that he has cited and discuss why it should or should not be accepted in your motion. Thank you.
Thank you.
Thomas Nicarello. I'm strongly opposed to the motion. What I heard was, police department referred Mr. Garza to another department in the police department to get the records that he was seeking. Mr. Garza testified he doesn't remember if he went or not.
No.
And then Mr. Garza was asked, did he get the records? And Mr. Garza's testimony was he doesn't remember if he got the records that he requested. So there is no basis for the motion. And certainly there's no basis to continue this. So I strongly oppose the motion because the police department acted according to the Sunshine Ordinance and acted according to the California Public Records Act. In the remaining 2 minutes I have though, I am troubled by the police department saying that if they give the record to Mr. Garza, they have to give it to the world. That's not the case. The case cited by Mr. Coma about the Black Panther Party didn't deal with medical records, it dealt with the debt collection agencies, where the court said if you give it to one, the records of a debt collection agency, you gotta give it to everybody. That makes sense, but not medical records. Police department could have Mr. Garza sign a release for his medical records, just to him and nobody else. And then they wouldn't have to give them to anybody else. And that's what hospitals and doctors do on a medical record request. You limit it to whoever's requesting it and nobody else. But as to the motion, there's no basis. There's no violation by the police department of the Sunshine Ordinance or the California Public Records Act. Thank you.
Thank you.
There you go. Mr. Cole also cited another case, which is Los Angeles Police Department versus the Superior Court. And the person may be subject, who may be the subject of the particular record sought, does not, because he's personally affected, have any greater right than any person to examine the record. So there are other police departments who seem to follow the same procedure. And I'm against the motion on the floor. 6726, withholding of records, doesn't give a timeline. And Mr. Garza's testimony was vague, it was conflicting. He said he got some, but he doesn't remember what he got. So it really doesn't apply to me the way I look at it. And the second one, 6727, justification of withholding, it also doesn't say when they have to say, well, we're going to withhold it for these reasons. So maybe it didn't happen right away when he went up to the legal department, maybe nobody told him, but they certainly directed him where to go. So they were helpful in that fact. So I don't think there's a basis for a motion. Thank you.
Thank you. Do I have any more public comment? Seeing none. Let's. Is there any more discussion or should we just vote? Member Highland?
Well, I think the public brings up a couple of good points, and one of the things was the owner of the video device deleting it. I meant to bring that question up earlier. Perhaps Sergeant Pedrosa could answer that, what exactly that means. That's really, always thinking about that. I'm not sure if we should continue. I would like to know where Ms. Pumphrey's not working, still city employee. That's also about a very valid question. Perhaps our clerk can inform us on that.
Mr. Cook?
I'm not aware of her new position.
I mean, regarding the deletion of the video, I think that, well, we could obviously bring that officer in here to answer, but when it comes to public records, like, were there any public records created from deletion of that video? The likelihood is not. I mean, if her captain told her delete the video, or she deleted the video on herself, and it was an oral communication, no public record would be produced to record report that incident. So I don't think that there would have been anything to give him, under those circumstances. But it would be interesting to,
It's troubling that they actually.
it would be trouble, I mean, I don't know if an officer or a superior actually asked her to delete it, or she deleted it on her own, or if it was a male or female, actually, I don't know about all that.
And if there's no video, they would have answered it, but the fact that they referred to it in their letter.
My video shows the person.
But I do wanna say that 5150 is a voluminous, partly detailed, partly not detailed, of rights and responsibilities that the police are to follow, that the state are to follow, that the mental health institution is to follow, and it is a confusing code. So I don't think that we have this magic, let's look to the code and we'll get an answer about every incident. And I definitely don't think that, when it comes to certain, and obviously, the issue with legal cases is all legal cases are never gonna be directly on point. That's the, I think that's what we, as attorneys and lawyers, do all the time, is find the most relevant case and say, this is the most relevant case. It may not be quite on point, but it's similar and like, and I think, I don't know of any, and we don't have any information of any cases where 5150 and I think it's 5150, 5325.1, 5325, which also talks about certain rights and privileges, including the right to privacy of that individual who has been detained and sent for evaluation for 72 hours. So, for me at least, it's not enough here to go forward. But
And the more I deliberate, I think I'm probably going to withdraw my second of the motion, because looking at an original request for information of a 10-day period, they did actually respond within 10 days. Even though it was an IDR and an extension was invoked correctly or incorrectly, in the end, the complainant received his information in 10 days. I hate to punish the department for essentially doing the right thing. So as a second, I'm going to withdraw my second motion. I can do that. Or do we just leave it and vote on it?
Well, we have to make a decision on that, actually.
I believe, Member Highland is entitled to withdraw a second.
Okay, so right now we have a motion and a second.
Is there a second on Member Pelto's motion? I do not see a second.
Okay.
I was just gonna say, maybe the part of the solution to this, if we're not gonna find a violation, we could certainly take this up at EOT and discuss further with the police what their procedures are, how they handle incident reports, et cetera, et cetera. Whether or not there was a violation, we haven't talked to the police in a while. Nice to see them, but we could probably delve a little further into how incident reports are handled. So I would just offer that.
May I suggest that we take no action on this item and we can create a hearing item
Yeah.
to take up that matter?
And for what it's worth, I just found sections 5202 and 5328 that were part of what Member Sims was referring to. But they talk about services, so it is very unclear whether these are mental health treatment services.
So having said that,
Sure.
I, as chair, I'm going to declare the matter concluded, but I will take public comment.
Madam
Well,
Chair,
yes.
you already had public comment when the
Yeah.
motion was made.
we must, you know,
Oh,
get
okay,
this
okay,
public
right.
comment.
Sorry, we already had that public comment, thank you.
So item number 2 and 3 are concluded due to